Hello friends, in the series on the income tax cases, today we will discuss a case which is based on revision proceedings under section 263 in consequence of passing the assessment order by the assessing officer under section 147. In this case also, the importance of assessment under section 147 has been highlighted because of the reason that it has been seen nowadays that whenever the notice under section 148 is issued to the assessee for the reasons which are recorded by the assessing officer, the assessing officer from the very first day starts making the inquiries which are not the part of the reasons recorded by the assessing officer. This is also a very debatable issue, that whether the assessing officer has a right to make any inquiry from the very inception of the proceedings under section 147 which are not part of the reasons recorded, and if some reasons are recorded and the assessing officer do not make any addition on those reasons, so whether the Commissioner of Income Tax has the power to do the revision on points which were not part of the reasons for reopening the assessment. This issue has been taken up by Delhi ITAT B bench in the case of Daffodills Pharmaceuticals Ltd versus Principal Commissioner of Income Tax. This case is reported in 129 ITR Tribunal at page number 63, and the date of the judgment is 19th September 2023. The facts of the case are very interesting. The assessment year is 1213. The assessee was issued a notice under section 148 on some reasons, and when the assessment proceedings were completed, the assessing officer did not make any single addition on the points for which the reopening was done. When this assessment was completed, the Principal Commissioner of Income Tax was of the considered view that the assessing officer, while completing the assessment, has not considered the two judgments which were vital for making the assessment under section 147. The Principal Commissioner of Income Tax was of the view that it was the duty of the assessing officer to consider those judgments. As all we know that for doing the revision under section 263, there are two ingredients which should be satisfied before initiating the proceedings under section 263. The first is that the order should be erroneous, and the second is that the order should be prejudicial to the interest to the revenue. Both the conditions should be cumulatively satisfied. If the order is erroneous but it is not prejudicial, it cannot be revised, and vice versa. Now, the question arises that whether every loss to the revenue can be termed as prejudicial to the revenue. For this, it is a settled law that if the learned assessing officer takes a permissible view while passing the assessment order which has resulted in a loss, then it is not prejudicial to the revenue, and it is not erroneous unless the view taken by the assessing officer is unsustainable in law. At the same time, an incorrect assumption of facts or an incorrect application of law will satisfy the requirement of the order to be erroneous. But since in the present case, the Principal Commissioner of Income Tax initiated the revision proceedings on the points which were never the reasons for reopening the assessment, so on this ground, the assessee was challenging the revision proceedings before the tribunal, and the tribunal said that in the present case, when the assessment is reopened, usually it is not open to the assessing officer to go beyond issues raised in reasons recorded. The tribunal said that the assessing officer's jurisdiction is limited to issues which are subject matter of reopening, and he cannot assume certain facts which are beyond his records. The tribunal said that he is required to go through the records in accordance with the reasons recorded. Although it is also a settled law that if during the proceedings the assessing officer comes to know that some other income has escaped assessment, then he can do the assessment of that part also. But from this case, it becomes very clear that the assessing officer from the very inception cannot enlarge his scope of making any inquiry from the assessee to do the various assessments. Hence, in the present case, the revision was based on the points which were never the part of the reasons. So the tribunal quashed the revision proceedings. At the end of this video, once again, I am repeating the name of the case. The name of the case is Daffodills Pharmaceuticals Ltd versus Principal Commissioner of Income Tax, and this case is reported in 129 ITR Tribunal at page number 63, and the matter has been decided by Honorable Delhi ITAT B bench on 19th September 2023. Thank you, friends.